Good morning, good afternoon, good evening. Once again, we are here to discuss an important officer of a company called the company secretary. In section 13 of the Companies Act of Ghana, 2019 at 992, when we were discussing the processes of incorporation, we did indicate that one of the officers listed in the application form and submitted to the registrar of companies for the incorporation process to be concluded is the company secretary. The company secretary had become so very important that Lord Denny, in the case of Panorama versus Fidelis, indicated that the company secretary is not the company secretary of old. This company secretary has transformed and can perform various duties to the company. The company secretary is supposed to be a professional, is supposed to have a fiduciary duties and act in utmost good faith towards the company, just as a director is required to do. The company secretary is not supposed to do anything that shows that there is conflict of interest. In fact, if there is a conflict of interest, this conflict of interest ought to be disclosed as the case is from section 192 to 196 of the Companies Act. So we are talking about a very important officer of the company. So this is part of the requirement of registration or incorporation procedures and processes. The company secretary, Lord Denny says, can enter into contract relating to his office or her office or the administrative duties of the company. And that contract will be binding on the company. So in the discussion that will unfold, we will emphasize on the qualifications of the company secretary. We will also emphasize on the duties of the company secretary, and these duties will include keeping company records, record about directors, record about company secretaries, filing of important document to the registrar of companies, and a company secretary is a requirement of the company law, that every company should have a company secretary. So in section 211 of the Companies Act, a company shall have a company secretary who shall possess the qualification specified in subsection 3. So a company secretary is a requirement of the Companies Act that every company should have a company secretary. And this company secretary should have qualifications that are desirable, qualifications that are required. The company secretary may be a body corporate. Remember, we said earlier on that a director shall not be a body corporate, but a company secretary may be a body corporate, except that when the body corporate is a company secretary, this body company must have as one of its promoters, subscribers, directors, or operating officers a person who is qualified to be a company secretary. So even if a body corporate is a company secretary, one of the top officers of this body corporate should be qualified as a company secretary. We will unveil some of the qualifications, but among the qualifications, the law requires that a company secretary, as part of his or her tertiary training or education, should have studied company law, practice, and administration. So the study of company law is very, very important to start the journey of becoming a company secretary. The company secretary is so crucial that we cannot discuss incorporation without discussing the company secretary. The directors shall not appoint a person as a company secretary unless that person has obtained a professional qualification. So obtaining professional qualification is key to becoming a company secretary, or a tertiary qualification that enables that person to have the requisite knowledge and experience to perform the functions of a company secretary. The company secretary should have a wide experience and qualification and rooted in the law, because per the Companies Act, the company secretary will be the one who will be guiding and directing directors to abide by the provisions of the constitution of the company and the company law. It is the company secretary who is required by law to guide directors about any new development about the law regarding the company. So a company secretary is so important, so crucial. And that person who should be a company secretary might have held office before the appointment as a company secretary, training, or has been articled under the supervision of a qualified company secretary for a period of at least 3 years. So even if these academic qualification and professional qualification are not apparent, it should be very clear this company secretary has gone through an apprenticeship with a qualified company secretary for at least 3 years, where his or her experience is tailored towards the acumen that is required for a company secretary. And these company secretaries should be a member in good standing of the Institute of Chartered Secretaries and Administrators, or the Institute of Chartered Accountants Ghana, having been enrolled to practice is in good standing as a barrister or solicitor in the Republic. So if you are a chartered secretary, you are qualified to be a company secretary. If you are a chartered accountant, you are qualified to be a company secretary. If you are a lawyer called to the bar as a barrister or solicitor and you are in good standing, then you can be a company secretary. The expression good standing has wide or varied or broad explanation. First, you must have paid your dues regularly and will not be owing. Then you are in good standing. Then again, you must not be caught by the professional ethics of your profession. You must abide by the rules of professional ethics. Then when you are able to do all that, then you are in good standing. You are in good standing relating to your professional conduct. Then you are in good standing relating to payment of dues and subscriptions that you are required to pay to your professional body. And if you do not qualify to be in good standing, you cannot be a company secretary. By virtue of an academic qualification or as a member of a professional body, appears to the directors as capable of performing the functions of secretary of the company. So it is directors who are appointing the company secretary. For the purpose of paragraph A of subsection 3 of this act, professional or tertiary level qualification is a discipline with an offering in company law practice and administration. So even if you do not study law, in your study at the tertiary level, the law requires that you might have studied company law and practice, and you must have studied company law and administration. This qualifies a person to become a company secretary. The key thing is that a person should have knowledge and experience in the law regarding the company and company constitution. Unless the constitution of a company otherwise provides, the company secretary shall be appointed by the directors for the term at the remuneration and on the condition that the directors consider fit and may be removed by them, subject to the right of the company secretary to claim damages from the company if removed in breach of contract. So the company secretary is appointed by the directors. They set the term that the company secretary will serve. They decide on the remuneration for the company secretary, and they set the conditions under which the company secretary will perform his or her duties. However, the directors are enjoined to ensure that if they want to remove the company secretary from office, the company secretary is removed according to law. They must not breach the rules of natural justice. They must just ensure that they abide by the rules in ensuring that they give proper notice to him or her. They give some space to defend himself or herself. And if they find it fit to remove him, they can go ahead to remove the company secretary. In that case, they have actually operated within the law. So there is no way the company secretary can be removed without recourse to proper process and procedure. Where a company carries on business for more than 6 months without a company secretary, the law says that is in breach of the Companies Act. And a company which does that is required to pay administrative penalty of 25 penalty units for each day that the company operates without a company secretary for 6 months. So 6 months seems to be a grace period. So if after the 6 months, the company operates without a company secretary, that is in breach of the law. And that would trigger the payment of administrative penalty. So the office we are discussing is an important office. And the law also says that when somebody is serving as a deputy and there comes a vacancy in the office of company secretary, the deputy shall not automatically occupy the position. That deputy might be asked by the directors of the company to step in the shoes of the substantive company secretary in an acting position. It is not automatic that if you are a deputy secretary and the secretary is no more by resignation or by retirement or whatever means to occupy the position, you must be appointed, you must be asked to occupy that position by the directors. So the company secretary shall, before assuming office, lodge with the company for onward transmission to the registrar the written consent to serve as a company secretary. So what is required by law is that when the appointment decision is being made, the company secretary is required to send a written consent to the company that I agree that I want to serve as a company secretary, having been qualified to do so in your company. Then the company would transmit that to the registrar of companies, because the registrar of companies must have directors, must have company secretaries file to them to be on their record. It is a requirement of law. If that is not adhered to, the company is at fault and will pay administrative penalty. What are the duties of the company secretary? As I said from the beginning, the duties of the company secretary have now developed, and they include assisting the board to comply with the constitution of the company and with any other relevant enactment. So the duty of the company secretary is to assist the board of directors to comply with the constitution of the company. The constitution of the company is meant to be followed, but it is possible that directors may not be cognizant with all the provisions of the constitution of the company. So it is the duty of the company secretary to guide them, to assist them. So the point is that if the company secretary doesn't have understanding of the law, doesn't have understanding of the constitution of the company, it will be very difficult for the company secretary to do so. That is why the requirement is rigid, and the requirement of law regarding companies is one of the fundamental requirements to become a company secretary. Keeping the books and records of the company. Keeping the books and records of the company. Membership of the company. Other documents of the company. Other records of the company are supposed to be kept by the company secretary. He is the custodian of the company document. For example, when the new company law came into being in 2019, the law says that directors are supposed to now disclose their conflict of interest to the company. And that conflict of interest is supposed to be lodged in conflict of interest register. It is the company secretary who is supposed to keep these records of the company and to ensure that they abide by the rules, ensuring that the minutes of the meetings of the shareholders and directors are properly recorded in the form required by the Act, preparing and issuing out notices in the name of the company. The notices that are issued by the company, secretary, must be in the name of the company, not his personal name, must be in the name of the company. And the issuance of notices shall not discriminate against any shareholder, against any director, or against any person qualified to attend meetings. If the company law or the requirement says that notices should be given 14 days, notices should be given 21 days, the company secretary shall not give notice to some people 21 days and give to some people 9 days. The company secretary should be fair in discharging this duty. The company secretary is supposed to prepare and issue out notices in the name of the company, and ensuring that the annual financial statement of the company are dispatched to every person entitled to the statement as required by the law, as required by the Act. Nobody shall be discriminated against in terms of dispatching or distributing the financial statement, which is a crucial document to all members of the company. So ensuring that all statutory forms and returns are duly filed with the registrar. So there are forms that are required by law to be filed by the company secretary to or with the registrar. The company secretary is supposed to abide by that. Maintaining the statutory register of the company, that is one requirement, that is one duty of the company secretary. Providing the board with guidance as to the duties, responsibilities, and powers of the board, and on the changes and development in the law affecting the operation of companies. So the company secretary is a teacher, leading the board, guiding the board to understand their duties, to understand their responsibility, and to know the width, the length, and the height of their powers, so that they don't go beyond their powers to enter into the realm of ultra vires. If there are changes in laws affecting the companies, it is the duty of the company secretary to brief the board of directors to always be in line with the law. The company secretary is supposed to inform the board of directors of legislation relevant to or affecting meetings of shareholders and directors and their failure to comply with the legislation and reporting accordingly at any meeting, advising directors on their responsibility as directors. So we cannot put anybody at all as a company secretary. It's no more a recorder and minute taker. The company secretary is a professional, discharging professional duty in the fiduciary way and within the principle of utmost good faith to the company. The company secretary also has apparent authority on behalf of the company to make contracts connected with his or her administrative duties. He will also have actual authority to enter into contract of this type and so bind the company. However, the company secretary has no apparent authority to enter into trading contract on the company's behalf. To borrow money in the company's name, no, that is not what the company secretary is supposed to be doing. To sign contract regarding the core mandate of the company, that is not the job of the company secretary, but he has apparent authority to enter into contract regarding her office as the chief administrator of the company. This was revealed in the case of Panorama Development Limited versus Fidelis Finishing Fabrics, where Lord Dennis espoused the value of the company secretary and claimed that the company secretary is not the company secretary of old. He can now enter into contract and regarding administrative duties, and those contracts will be binding on the company. The terms and remuneration are supposed to be fixed for the company secretary by the directors. The company secretary is supposed to register directors and company secretary. So it's a requirement for the company secretary to keep the register at its registered office of directors and company secretaries. The company secretary is supposed to go through registration of particulars of directors and company secretaries. A company secretary shall, within 28 days of a change occurring among the directors or in the company secretary or in any of the particulars contained in the register, other than those required under paragraph E of subsection 3 of section 215, sent to the register for registration notification in the prescribed form of the change, specifying the date of the change. So if there is a change in the number of directors, that change must be recognized and reported or actually presented to the register of companies. So the company secretary must be abreast with all these things to be able to register the particulars of the company, to be able to register the particulars of directors and particulars of company secretaries. The company secretary, just like directors, owe fiduciary duty to the company and must act within utmost good faith and avoid conflict of interest. The company secretary is at par with directors in ensuring that they act in the interest of the company. As I said earlier on, the company secretary must be removed by the directors in line with the law and not arbitrary. When that arbitrary removal of company secretary takes place, then the company secretary can press for legal action for his right to be respected for compensation. The company secretary is supposed to keep all the records of accounts and preparation of financial statement. And the company secretary, when the financial statement is audited, is supposed to be the custodian of the company financial statement and circulate same to all stakeholders who are supposed to be served or be provided with the financial statement. Where a document is supposed to be signed by a director and a company secretary, a company secretary shall not serve as a director and a company secretary at the same time. That is not in consonant with the law. So we have gone through a company. We have looked at who a company secretary is. We look at what are the qualifications of a company secretary. And we also look at the duties, the functions, the role, the responsibility of a company secretary. Now, I wait for your questions. Thank you.